Aloha, everybody. Welcome to the Senior Counsel Division Coffee Hour for September 2023. This month, we are absolutely honored to have Chief Disciplinary Counsel Bradley Tamm and Associate Chief Counsel, Deputy Chief Disciplinary Counsel Carol Richelieu talking with us about winding up our practices and succession planning. This is a presentation that Chief Tamm has given in the past, been super valuable. And so this is a great presentation to be part of. Chief Tamm is the Chief Disciplinary Counsel of the Hawaii Supreme Court. He's administrator of its Lawyers Fund for Client Protection and the SCH Rule 2.20 Trustee Administrator regarding deceased, disbarred, disappeared, or disabled attorneys. He's previously served as attorney member of the Disciplinary Board from 2006 to 2012, and its outside general counsel in 2018. Mr. Tamm's private practice was generally limited to federal bankruptcy law. A 1991 graduate of Thomas Jefferson Law School in San Diego, he's admitted to practice in Hawaii and California, inactive in California. Also admitted before the U.S. Supreme Court, Ninth Circuit Court of Appeals, U.S. District Courts in Hawaii and California, as well as the U.S. Court of International Trade and the U.S. Tax Court. Carol Richelieu is Deputy Chief Disciplinary Counsel, as of yesterday, of the investigative section. She's former Chief Disciplinary Counsel for our Supreme Court and Fund Administrator of the Lawyers Fund for Client Protection. Carol is a legal ethics expert and instructor. She's made numerous presentations on legal ethics, client protection, practice management, and professionalism, as well as written many articles and contributed to numerous manuals and served on many committees in Hawaii and nationally. She's also a very active community volunteer and is past president of the Senior Counsel Division of the Hawaii State Bar Association. So, Chief Tamm, Carol, thank you very much for presenting today. Please take it away.
Okay, thank you. First of all, a little bit of a disclaimer. Carol was the Chief Disciplinary Counsel for much longer than I have been or expect to live long enough to be. So I was kind of floundering when I first came into the job, and I talked Carol into coming back. So if there's a dispute between what I say and what Carol says, do what Carol says. She knows better. Okay, and you all know Carol in the Senior Counsel Division here. Let's say we're going to cover 3 issues today. First issue is going to be what to do with your files. You've all heard me say time and time again, when in doubt, throw them out. That's the theme that I always pursue, and Carol's going to give you some of the drill down and nitty gritty on it. Then the second part of today's presentation is going to be what to do with leftover client funds. Most of you, as you get right on the verge of retiring, if you're not presenting, would you please mute your microphones so that we don't have feedback here? Okay, a lot of you, once you get to retire, you'll find out that you've got money left over in your client trust account and you don't know who it belongs to, or the client disappeared and you can't find them. So we're going to talk about that a little bit. It's a very common problem. And then third, we're going to talk about what do you do after you retire? Exercises to keep your brain from turning to mush. With that, let's go ahead and turn this over to Carol to start on disposition of client files. Take it away, Carol.
Thank you. Thank you, everyone, for attending today. I really appreciate it. And I'd like to say a special aloha to all my Senior Counsel Division folks, having been involved with Senior Counsel Division since the inception. I would like to kind of tie into our topic today, which is closing a law practice and succession planning. It is actually a really, really huge topic, and I can't let this opportunity pass without reminding everyone, begging everyone, please designate in advance another attorney. to take over, in the event of death, disability, incapacitation. It's been recommended by the ABA since at least 2007. And those of you who know me, I've been harping on this for decades in Hawaii. It just saves so much grief for so many people. So I had to put a plug in for succession planning. Today, we're going into kind of the nitty-gritties of, and this is just part of succession planning, the files and the funds. This is just merely a part of it. So with regard to the files, speaking as a local of a certain age, we like stuff. And we especially like our paper. We have to have our paper. And, despite the advent of, the cloud and Dropbox and everything else, we still tend to really get into having paper. I admit I do it too. When I go to an event, I still want a paper ticket to show. Or when I sign up for specials, I will have a paper handy. It's a very difficult, it's a cultural thing that we do. We like our paper. But today, I hope to be able to convince you folks to let it go. We've got to break the habit when it comes to the disposition of client files. Now, if we were all in a room together, which I sort of wish we were, but it's much safer this way. I won't do a show of hands because I can't really see them all, but I would ask you to think. Now, under the Hawaii Rules of Professional Conduct, what is the rule regarding disposition of client files? Are you folks all thinking? All right, so is anybody sitting around thinking 6 years?
Oh, sorry, Carol. I have everyone muted at the moment.
Oh,
but
okay.
if-
Well, you
yeah.
can just wait. They
Yeah.
can just think to themselves, Desmond. Thank you. Because, or maybe you're thinking to yourself, well, disposition of client files, I've got to keep them 7 years. Well, when in fact, the only rule in the Hawaii Rules of Professional Conduct with regard to records, it's not client files. There is no such rule. There are a couple of rules deal with books and records only. And if you want, you can keep the paper, although it's a lot better to do it electronically, but you can keep the paper. So I would refer you to Hawaii Rule of Professional Conduct 1.15a, records. That rule says 6 years after termination of the representation. I would also refer you to the Hawaii Rules Governing Trust Accounts, 4C. This one says 6 years after completion of employment to which they relate, or the last transaction on the count, whichever is last. Now, which one of those you want to pick, that's fine. But again, it only relates to books and records. And there is a whole list in the rule about what you need to retain. And I would suggest to you that that is more than enough stuff for us to keep. Can you do the slide, please? Slide. Yay, slide. Now, this is the rule that you need to pay attention to. 1.16D, dealing with representation. As with all the rules, it's really important to read the rule carefully. You will see it says upon termination of representation. This is termination of representation. Some attorneys think, oh no, it just pertains to withdrawal. This is actually termination. Then the rule tells you, you take these steps to protect clients' interests. And these steps include giving reasonable notice, allowing time for employment of other counsel, surrendering papers and property to which the client is entitled, refunding any advance payment fee or expense not been earned, and provide an accounting or kind of request. Now, this is the rule. So what does that really mean? That if this rule is complied with, you don't have any client files. You do not have to deal with it. You should not have any closed client files. I mean, you can keep copies if you want, you know, for yourself, but at your own expense, of course. And what does it mean when it says to which the client is entitled? That could be a whole seminar in and of itself. If you look at Hawaii Rule of Professional Conduct 1.6D, there is a comment, excuse me, and it's comment 10, and I would refer you to read it. It's not definitive, but it is helpful. I mean, what is the client entitled to? So it provides some, the general rule of thumb is kind of like it's theirs. So, you know, give them their paper, give them their records, give them their stuff. It's their stuff. And the other thing about this rule too, it doesn't say to whom. It says surrendering papers and property, what they're entitled. So just keep in mind that could be the client, or that could be successor counsel. But whatever you do, have it confirmed in writing that you're giving the papers and the property to the right person. It can be all kinds of heck if you start surrendering to somebody that claims to be entitled when in fact they are not due so. So if compliance with this rule, again, you shouldn't have to deal with this issue. It would be, you don't have any of the files left. And I sometimes suggest as a practice tip, address this in your written attorney-client fee agreement. Address the issues of the files. Now, what happens if we don't comply with this rule? That upon termination of representation, we don't give them their papers and property and their stuff. Some of, you know, what happens is if you don't do that, you're going to be stuck contacting all your former clients. You're going to have to ask them what to do. You're going to have to store all this stuff. If you can't find them, you're going to have to start looking for them. You get stuck with the files, and especially in the old days, you know, with originals, you know, with estate planning and wills and trusts and all that, stuck forever with it. And then there's the storage issue. And then if the attorney has to do the actual destruction, that's more money. And then they have to keep records of what they destroyed. They have to, of course, preserve the confidentiality of those records. It can only be done a certain way. And then possibly, you know, consult with their malpractice carrier about how they should handle this issue, which should not have been an issue if they had done it right. And I would mention another thing too. The concept of retaining liens. It's a Disciplinary Board Formal Opinion number 28. They are forbidden in Hawaii. And so it's best to avoid the tug of war over files. It's happened, attorneys, you know, well, you haven't paid me, so I'm not going to give you your files. They're entitled to the files, and you can't have that kind of tug of war. And I've seen numerous complaints with that particular issue at it. Now, if attorneys do comply with this rule, it's a lot less headache and time and money. And it spares later on in the event of certain events which are inevitable in our lives, the family, the friends, the clients, your colleagues, from having to deal with this, from having to possibly have a trusteeship, someone come in and, court ordered and take over and do all of these things. It makes winding down a practice, closing a practice so much easier. It's just got a benefit to everybody about what happens. So again, we don't know, when something's going to happen. But if this rule is complied with, then it benefits everybody. So just discard all your notion about 6 years, 7 years, every piece of paper, and read the rule and try to comply with it. Next slide, please. So just to kind of sum up my section so that Chief Tamm's got some time here. This is the DB site, dbhawaii.org. So you can just go to it and look under resources and go to the Hawaii Bar Journal and CLE for some materials on this area. Next slide, please. And you will see under that tab, the Sole Legacy article, which was done by Chief Tamm, retiring from the practice of law, returning client files after termination, disposition of closed client files. And I may have written all of those, I can't remember. And in addition, there's also, I did pen an article in the Hawaii Bar Journal in October 2011 on winding down a law practice. I would also refer you to, there's a Hawaii Bar Journal article September 2016 on file retention and destruction, which is a really good article with the one caveat that, attorneys cannot destroy originals. You're stuck with them forever. And in addition, I would refer you to one of the best kept secrets is the Transitioning Lawyer Committee of the Hawaii State Bar Association. And you can just, look that up, and there will be all kinds of material that we've put together dealing with transitioning out of practice. And you'll find in there too another article I penned about how to handle files upon retirement. But ultimately, what would be best for you, your clients, everybody is you shouldn't have the files. The files should have been surrendered to the client or whoever is entitled to receive them. So that's a real thumbnail sketch. I hope it helps. And there's a lot of resources out there, and I would encourage you to use it. Chief Tamm?
Okay. Trying to run the slideshow here. Before we get off the topic of client files, I would want to reiterate what Carol said. I get people calling me all the time on this, and the first question I ask is, how long are you supposed to keep your client files? And I get this 6-7 years is a common refrain I get. And the bottom line is like Carol said, there's no rule that says you have to keep client files. Once you've terminated representation, you are supposed to have already given back to the client everything to which they're entitled. And from then on out, you can destroy them at will. Your insurance carrier may differ somewhat, but as far as ODC is concerned, we don't expect that you have your client's file after you've terminated representation. If you've complied with Rule 1.16D, the biggest thing that I worry about is if you wait too long and you end up dying with 10,000 boxes of files stored, your family is going to end up having to pay to have ODC go over there and hire an inventory attorney to go through and try and find your clients and return the stuff. You see, you can dispose of it. You don't have to get permission from anybody. But if you die and ODC comes into possession of it, well, we're not the attorney of record. So we've got to actually go out and find the client and try and get the stuff returned to them. So you've just created a big mess for ODC, and ODC doesn't mind. You know, we collect your dues every year, we get paid, but the Supreme Court requires that we go after your decedent estate to recover the expenses. That's a big burden to your family. You don't want to leave them with that problem. So please cooperate with us and try and get rid of the stuff before your time comes. And it's just, you know, follow the rules. When I was in my private practice, at the end of every representation, I would write a termination letter. And in that termination letter, I'd say, you know, I think I've already given you back everything to which you're entitled, but I still may have files here. If you want copies of them, please contact me within the next 90 days. If you haven't contacted me within 90 days, I will destroy these files and they will no longer be available to you without any further notice. And that letter, the whole purpose of that letter was to cover my okole. So I didn't have to be worried about the client coming after me for not holding on to the files. Okay. Oh, as far as digital files go, if you want to get rid of digital files, I had a lady call me up one day and she said she was fixing to retire and she wanted what to do with her client files. And I says, well, you know, unless you properly terminated, you might want to contact your clients and see if they want them back and then mail them back to them. She says, mail them? And I said, yeah. And she says, you mean I got to print them out on paper in order to mail them back? I said, wait a minute, you got digital files? And she said, yes. And I said, oh, that's an easy solution to that one. Look on your keyboard for a key that says DELETE. Did you see it? Okay, push it. You know, so if you got digital files, it's so much easier to get rid of this stuff. You just delete. Okay, so let's move on and let's talk about client funds. This is a common call that I get several times a year from an attorney that says, I got some money left over in my client trust account and I can't find my clients. I know when I closed my law practice back in 2015, I had like $258 left in my client trust account from a client that just, it wasn't even a client actually, it was a party that I was supposed to pay. I was a litigation trustee for Hawaiian Telecom when it went through bankruptcy. And one of the claimants was a corporation that dissolved and I couldn't find the principals or anything. So I had all this money sitting there and I'm trying to figure out what to do with it. You know, you can't pocket the money. That's a rule, right? Lawyers are never allowed to pocket money from clients. So we got to take a look and see what the rules are. Go to the Hawaii Rules Governing Trust Accounts. The Hawaii Rules Governing Trust Accounts, what I call the HRGTA, is incorporated by reference into Rule 1.15 of the Hawaii Rules of Professional Conduct. Rule 4 of the HRGTA has to do with trust account regulations and minimum trust account records. Okay, these are your minimum standards that you have to have with regards to trust accounting. Now, Rule 4C, this is where you find the 6-year rule that Carol was talking about. This is your records and books. This is the stuff that the 6-year rule applies to. And Rule 4C says, every attorney and law firm who practices in this jurisdiction and maintains a trust account shall maintain complete and current financial records of account for at least 6 years after either completion of employment to which they relate or the last transaction on the account, whichever occurs last. So this is the rule that says you got to keep your client trust account records. It's not the client file, not the 40,000 pages of court pleadings and your scribbles from depositions and stuff like that. This is your client trust account records, your bank statements, your quarterly reconciliation statements, your client subsidiary ledgers, the gazinas and gazadas of the account. Gazina meaning that which goes into the account, and gazada, the stuff that goes out of the account, the checks you issued, the deposit slips and things like that. And yes, some of you got a question. Banks don't give it to me on paper anymore. Well, that's true. You can keep digital records of it. I had an attorney tell me I can't get copies of my canceled checks from the bank. They want to sell them to me. I sign up for their online system. Every one of the Hawaii Justice Foundation approved banks that provides for online access, you can get free copies of canceled checks through the bank's online portal. And I verified that with every bank that I have been told doesn't provide it. I went to the bank and I found out, yes, in fact, they do provide it. So if you're having problems with your particular bank, give us a call and I'll hook you up with the bank's chief legal officer and show you how you can get copies of your canceled checks. All right. What to do if you have leftover money in your account? It's a perplexing problem. And as I said, you get this call and it says, I'm getting ready to retire and I got some money in my Ulta account, which belongs to a client and I lost contact with years ago. What can I do? Well, there's the easy solution and there's a hard solution. Relevant HRPC rules. 1, you're required to return all unearned fees and advance retainers to your client upon termination. That was Rule 1.16 that we discussed earlier in the hour. Okay, so on termination, you should have already returned this money to the client. But then case is over, trying to return the money, and you can't find the client. It happens. It's not impossible for that to occur. So the first thing you got to do, you got to make an effort to find the client. We find this at HRPC Rule 1.2a, which says a lawyer may take such action on behalf of the client that is impliedly authorized to carry out representation. Impliedly authorized, that should evoke these flashbacks to law school. Remember your agency class? There's actual authority, implied authority, apparent authority. Okay, implied authority is that which is reasonably implied by your agency status. As an attorney, you are the agent of your client principal. So you have an implied authority to do things on your client's behalf. And if you're holding your client's money, finding the client is impliedly indicated in your retention as an attorney. So you've got an obligation and you've got authority to do it. So next, we take a look at what is your obligation to exercise of that authority. And your obligation is to keep your client reasonably informed about the status of their case. And that's found at HRPC Rule 1.4A3. Keep the client reasonably informed that, hey, bozo, you got money left over in the trust account. Okay, I got to find you and I got to communicate this to you. And then next, you have a refund and account for any fees that are left in the account. And this you'll find in the HRPC rule dealing with attorney's fees. It's Rule 1.5G is the attorney's obligation to refund and account any funds. So this is all the legal authority you need to go to the next step. Take reasonable efforts to find the client. Now, HRPC Rule 1.5A, now 1.5 is attorney's fees. 1.5A is a subparagraph that deals with reasonable fees. And the lawyer is impliedly authorized to charge the client for efforts to find and refund the balance in trust. Also, look to your fee agreement and the scope of representation. Most fee agreements have in here something that I'm going to do X, Y, and Z for you, but if other things come up that are outside the scope of this agreement, we can negotiate it, blah, 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 and that I'm impliedly authorized to do things which are necessary to keep you, to protect your interests. You know, do a little bit of interpretation there, but you are impliedly authorized to try and find your client to return the money to them. And also another important thing that I hope is in your fee agreement is some kind of obligation the client has to you, that the client has an obligation to keep you reasonably informed of the changes in their address and their communication numbers. So if the client has breached their obligation, then you've even got more authority to try and hunt the person down. Now, first thing I do when I try and find a client is this magical mystery thing that occurred late in my life that I discovered. I just stumbled upon it one day, and it's called Google. You go into Google, you type in the client's name, you'd be amazed what you can find. Okay, a lot of times you can find a missing client just by Googling them, going to Facebook and typing in their name, or some of the other things, LinkedIn if they happen to be professionals. There's all kinds of different places you can go. There's also available on Westlaw. Westlaw has a public record search called People Finder. You can go in there and type in some information, and they allow you to drill down on more information. Maybe you got your client's social security number because you did a settlement on them, or their date of birth, or you know what residence they happen to have. And you can type in some information. You can even find John Smith. As common as that name is, if you've got some additional information which is unique to your client, Westlaw, public records portal, enables you to find that. And the time that you spend looking for the client, remember, you're impliedly authorized to do this. You were hired to work by the hour. You can charge them by the hour to try and find the client. So let's say you're charging $350 an hour. That's your basic fee. And you've got $400 in the client trust account. You're trying to find your client. I don't think it would be unreasonable to spend an hour trying to find your client. And by the time you've done that, after GET tax, there's less than $40 left in the client trust account because you've billed them properly. So if you've got a relatively small amount of money left over in your client trust account and you're making reasonable efforts, now I'm not talking about doing a skip trace when you didn't need to do a skip trace. I'm talking about you got money left over, you're trying to find the client, and you spend time doing it and you can't find the client, then bill for it. And then pretty soon there's no money left in the client trust account. Problem solved. This works for small amounts of money. But if you got large amounts of money in the client trust account, that's a big problem. Now, I had one guy present me with a situation where he had 1.5 million left over in his client trust account and couldn't find the client. Okay. Please don't go to Google every hour on the hour and spend an hour Googling things and then charging them fees to eat up that $1 million. That's unreasonable. And that's going to get you in trouble with the ODC and probably get you sued, maybe even criminally indicted as well. So you don't want to do that with large amounts of money. Remember, reasonable effort. So if you've got undisbursed settlements and a significant amount of money, you may require that you go out and you hire a professional skip tracer. They've got a retired FBI agent that works here in Honolulu that advertises doing skip tracing work. I'm not going to say whether the person is any good or not, but these are some of the things you can look at. There's other methods that you can go about to try and find people. You may want to contact your insurance carrier, because if you don't do reasonable efforts and somebody calls you on it, you're going to get sued for it anyhow. So your malpractice carrier may be able to help advise you on finding the client. And then finally, of course, there's the one guarantee that you can do. If you can't find the client and you've expended reasonable efforts to do it, you comply with HRS Chapter 523A, which is the lost and unclaimed funds rule, or what we commonly know of as sheet. It's a fairly complicated process. It's not for the faint of heart, but it can be done. And it's a way of turning money over to the state for the general fund. One of the nice things about turning money over to the state for the general fund is, unlike certain pieces of property, if you turn over money to the state, your client or the client's legal successor can claim that money 100 years from now, and it'll still be available. There is no limitations period on when claims can be made for unclaimed funds through the sheet registry with the Department of Finance for the state of Hawaii. And by interpleading the money into a sheet, you have covered yourself ethically and you don't have to worry about any further obligations there. So large sums of money, that's a special circumstance. And when that comes up, you're going to have to deal with it accordingly. Okay. Document all the efforts that you do in the process of trying to return this money. Remember, a lawyer can never, under any circumstances, pocket the lawyer's money, the client's money. Just because, oh, I can't find the client, so I guess I get to spend it. We recently had a lawyer do that. Most of you probably know him. I'm not going to repeat the name, but he had a former client and the money was in a safe deposit box and the bank has sheeted it to the state. And the lawyer went and petitioned the state and said, this is my client. I don't know where my client is right now, but I'm going to claim the money and I'll find the client later. And it turned out that it wasn't really a truthful statement. And the lawyer had a tremendous ego, I guess, and turned around. And when the state said no, they weren't going to give him the money, what did he do? He sued the state. And in ensuing litigation, the state investigated it and found out that he hadn't represented his client in decades, had no idea whether the client was alive or dead, and was basically just trying to pocket the money. And needless to say, when it came to ODC, we charged him and he resigned with disciplinary charges pending, which is otherwise known as disbarment by consent. So no, under no circumstances can you go and claim that lawyer's money. And bear in mind also, in the ODC, there is no statute of limitations. So no matter how long ago you pocketed clients' money, the ODC can still charge you with misappropriation. There's no statute of limitations there. Okay. Another thing is if a lawyer has pocketed money, we have a thing called the Lawyer's Fund for Client Protection. Clients can make claims against the lawyer's fund. And if the lawyer's fund ends up paying the claim, it becomes a lien against the lawyer and the lawyer's estate. It's reduced to a judgment and is recorded with the Bureau of Conveyances. And you say, well, the lawyer's fund can only pay for dishonest conduct. Well, dishonest conduct under the lawyer's fund rules is a very broad term. It doesn't require that you prove that the lawyer was evil. It just means that the lawyer did something which is not explainable under the rules. If a lawyer is paid an advanced retainer and the lawyer happens to die without refunding the money to the client, hopefully the money's in the client trust account. But if the money somehow got transferred to the general business account, it's presumed to be dishonesty and the lawyer's fund can make the award. So this is something that can come back and bite you if you're still alive. Lawyer's fund pays out a claim. It's an automatic suspension from the practice of law. And if you're dead, it becomes a claim against your estate. And if you're hoping to leave something over for your family and your survivors, you don't want to go that route. So don't play with the client's money. We all learned that in law school, that, don't misappropriate funds. And when it comes to trying to figure out what to do with leftover funds in your client trust account, it's not a solution to pocket it. So anything you do as far as trying to track down your client and show that you're not pocketing unearned money, you're earning the money, you're making reasonable efforts to find the client, document it, and keep a record of it, because this can come back and bite you. All right. That's pretty much it when it comes to client files. We're at the 15-minute warning bell here. Before I depart for client files, does anybody have any questions? Let's take a look and see what's in the chat box.
Yeah, I can read out the questions. So looks like there. So if anyone has any questions, please put them in the chat box and I'll read it out loud. And looks like we do have a question. Is there a rule that you must keep a record of complying with 1.16.
There's no rule that says you have to comply with Rule 1.16 that I'm aware of. Carol, you aware of one?
There isn't a rule of keeping a record that you've complied with it, if that's the question, correct?
Yeah, from an ODC standpoint, no, there's no such rule. But as a matter of common sense, and I guarantee you that your malpractice carrier is going to tell you this. And if I was a lawyer, still, I can't do private practice of law, right? Because I work for the government. But if I was your lawyer, I would advise you to keep evidence of your compliance with your termination of clients, and keep a copy of the letter that you sent them that said, you know, the kiss goodbye letter. You know, our relationship has been real, it's been nice, but it ain't been real nice. Here's your money, get your files, that sort of thing. Keep a copy of at least that letter. I will tell you that I started digitizing my files in the mid-90s, and every client I ever had, and I represented over 6,000 people in my practice, I've got termination letter copies, and keep it on Dropbox in the cloud. And I've had clients call me 15, 20 years later and say, you didn't give me back my stuff. And I send them a copy of the termination letter and say, see, I did. And you know, I complied with that a long time ago. I don't have your files anymore. So that's the answer to that question. Okay.
Okay, next question is, sorry, we have two more in the chat box. You spoke of having been retained hourly. What if there are remaining funds where you were hired on a contingency basis? Can you search?
Or flat rate fee or something like that? Yeah, that is kind of a problem. In my bankruptcy practice in the early days when I represented debtors, most of my work was on flat rate fee agreements. And I think we were charging $500 for doing a simple Chapter 7 back then. And I always had a little provision in there that additional fees may be charged on an hourly basis if it's outside the scope of the agreement. You know, some kind of a catch-all clause in there, subject to additional negotiations and stuff. Hopefully you've got something like that in there. But let's say you've got a straightforward contingency fee agreement or a flat rate agreement, and there's just no wiggle room in there for extra stuff, which is not within the scope of the agreement. I think that under Rule 1.2, it could successfully be argued that you have a duty, you have an implied authority to do that which is reasonably necessary to secure your client's best interests. And then your Rule 1.4 obligation to communicate with the client, and then your 1.5 obligation to document and account for funds and stuff like that. I think that gives you enough wiggle room to at least proceed quantum merit and charge on an hourly basis for reasonable services necessary to follow up on it. Okay.
Yeah, there's also, I think there was also part 2 to that question. I don't know if you touched on it, Chief Tamm, but can search time be billed at an hourly rate?
Can what be billed at an hourly rate?
Search time.
Oh yeah, and that's what I generally would recommend. But be reasonable. Okay, if you know, maybe you want to discount it a little bit. I don't know. It's how's it going to look? You know, what I'd be wary of is you've got $2,000 left over in the trust account, so you document 4.6 hours of Google searches. You know, I don't think that's going to pass the smell test. You know, so it's something that you got to focus on. What is reasonable under the circumstances? Remember, you are the client's fiduciary. You have a duty of loyalty to do that which is reasonable under the circumstances.
I might add that reasonable too. I mean, in that situation, full-blown attorney's fees, or is this really more an administrative function? Some things staff could do or a paralegal do just as well. It doesn't take much expertise.
Yeah. Rule 1.5A has a laundry list of about 12 items that constitute what is reasonableness. So it's not in black and white, but you know it when you see it. Okay. There
Chief
was a
Tamm,
question about shredding documents, and somebody has something about goodwill.
it's a comment. So
Oh,
it's a,
okay.
yeah, it's a comment.
Okay. Well,
S-
we use Goodwill for shredding. They're the least expensive, and they're usually the first one on the spot. Call Shred It and Access their expensive services. But whatever it takes, when you destroy client files, just make sure they're securely destroyed. Carol mentioned in one of our articles she wrote, she said, "Don't throw them in the dumpster." Okay. And it had
Don't
one
give them
guy
away
that
as scratch paper.
Yeah, I had one guy that decided to close his law practice, so he wasn't going to pay public storage anymore, and he just let him auction off 250 bankers boxes of client files, to the highest bidder. And fortunately, the manager of public storage called me up on the phone, and he says, "Can lawyers do that?"
Mm.
By the way, that guy resigned with disciplinary charges pending. So okay.
Okay. Okay, just letting you know, Chief Tan and Carol, there's 2 more questions in the chat box, but we can get to it towards the end of your presentation.
Yeah, let's move on here because we only got about 10 minutes left here. Post-closing exercises to stay mentally fit. I was a young man. I had just got out of the Army, and I got a job working in a factory. And I'm sitting there working on an assembly line, and the guy next to me, I forget his name, but he was ancient. I mean, he was so old. Bear in mind, I was 21 at the time, and this guy was 64 and a half years old, God, dirt doesn't live that long, right? And he was all looking forward to retirement. And I worked on the line with him for a couple of months, and then his retirement came up, and they gave him a cheap Mickey Mouse watch and sent him out the door. And I was supposed to meet with him 2 weeks later, and we're going to go have a beer. And his wife called and let me know that he had just died. And I was like, oh my God. And then that's what I learned when I was 21. Never retire, because if you retire, you're going to die, right? So that's why here I am at 71 and I'm still working. Now, how many times do you know of people that pass away shortly after reaching that golden year and they stop working? It's not just an obnoxious set of numbers. It's real. People deteriorate rapidly once they have nothing to do anymore. I watched it happen to my dad. I've seen it happen to many people. So what do you got to do to keep mentally fit, physically fit? And we all go to our doctors, and our doctors tell us to stop eating so much and watch our cholesterol and take your Lipitor and all these other things. And it all kind of makes sense, but okay, we're all kind of busy and we don't want to pay attention to it now. Well, start thinking about it, because your time ceasing to practice law is coming up, and it's something you want to take a look at. So what are you going to do in retirement? A friend of mine retired. He's 1 year older than me, so he is older than dirt, right? Because I'm dirt. He just told me at lunch the other day, he's going back to college to finish his PhD. Whoa. My sister, who's two years younger than me, she retired after a long career on Wall Street. After retirement, she went to college in Florida and got her Bachelor of Science degree in nursing. And now she's working as a registered nurse. And these are people who are having a blast in retirement. Okay. One of the things that science has showed is if you get involved in educational activities, you start working this old noodle up here, it will reduce your chance of dementia by 40%. And I don't know about you, but I hope my brain stays functional until my body just quits underneath me. My mother passed away with Alzheimer's, and it's really, that's hard. If you've gone through that with people, so double down. It doesn't take a lot of physical exercise, and it's really not that bad to start taking night school courses or get involved in something that gets your brain moving, something more than operating the channel changer on your TV. It's just not a good way to proceed in life. All right, so I scanned Google getting ready for this course, and I wanted to look at, what is it that we can do, and I came across this article, and it says 20 amazing ways to live your life to the fullest when you retire. Look at these guys. Do they look like they've retired? I mean, these guys got to be 30 years old? Yeah, well, and you go down through the laundry list on amazing ways that you can do things and retire, and there's things like learn how to cook, stuff like that. What a boring list. So I said, there's got to be something better. So, of course, I take a look at it and I say, well, we're lawyers. One of the great things about lawyers, okay, we're not football players. We don't have to be in top physical condition. All we got to do is keep our noodle working, all right? So make your brain work. Volunteer or do light employment work. You've been a lawyer all of your life and you were good at it. Maybe you don't want to totally disconnect. And so I come up with a concept. Now I retired, I closed my law firm in 2015. And that's when I, told the landlord, it's been nice, but it ain't been real nice. I laid off the staff and went and worked out of my home. I kept two clients, two good clients that were steady payers and never gave me any grief. And I just worked part-time out of my home from 2015 to 2018. And it was nice. It was nice. Then in 2018, I decided to hang it up entirely. And in March of 2018, I hung it up. By June or July of 2018, I was bored. I mean, you can only go for so many walks on Waikiki Beach, the ladies look amazing, but I just felt like I wasn't doing much. And then I got a call from the court and they asked me if I wanted to come back to ODC. And it was like, yeah. Of course, I acted like it was killing me to come back to work, but I down deep inside, it really said, thank you, and give me something to do. You can do volunteer work as a lawyer. You can help out other people. We got Volunteer Legal Services of Hawaii, VLSH, one of my favorite activities. Legal Aid Society of Hawaii. They've got these access to justice clinics and stuff like that, where you're covered by their malpractice insurance and you just talk to people on the phone and you give them direction. You have no permanent responsibilities to them and stuff. It just allows you to keep your brain moving. And it's very important. HSBA has all kinds of activities for you to get involved in. And then, disclaimer, how about the Disciplinary Board? We're looking for hearing officers and settlement officers. How would you like to sit in and play judge for the day and decide cases that come before the Disciplinary Board? If you're a lawyer licensed to practice law in the state of Hawaii, we can use you as hearing officers. We do occasionally have people who don't want to settle and we got to go to trial. Also, there's people who do want to settle, but they want a little bit of help in settlement. So we're looking for voluntary settlement officers. These are volunteer positions. They're not going to take up a huge amount of your time, but it allows you to keep engaged and keep going. There's also light employment work. Okay, light employment work can include part-time jobs, and the Office of Disciplinary Counsel does have part-time employment. Recently, we hired a retired person. Carol, raise your hand. Carol retired from the Attorney General's office. She left here in ODC and went to the AG or DCCA. I'm sorry. And she retired from DCCA. And then she was sitting in retirement. And of course, I found out she retired. So I called her and said, Carol, you come back? And she works part-time for ODC. And we pay $75 an hour. And she is now the deputy chief of all the part-time people here. And what our part-time disciplinary counsel do is, and this is great for old folks, okay? For lawyers who have been around the block, How many people complain about their lawyers? They complain by the hundreds. And if I assign that to a young person looks at the complaint and they don't know what it is that lawyers have to put up with on a daily basis. So they've got to get into this in-depth investigation trying to figure out whether the lawyer breached their duties or something that an old experienced lawyer could probably take a look at and within 15 minutes ask exactly the right questions and wrap the case up and determine whether or not there's any potential violations here. That's what we're looking for, is older lawyers who are in semi-retirement who just want to take a look at a complaint that comes in, get the other attorney's side of the story, compare it to the complainant's side of the story, and decide whether or not the complaint has legs. If it has legs, you send it back to ODC and we'll assign it to a full-time prosecutorial staff. If the complaint doesn't have legs, we'll send it to a reviewing board member and we'll end up with getting the complaint dismissed. The benefits is lawyers, we don't want lawyers in Hawaii to have to sit and wait 1, 2, 3 years for ODC to figure out whether the complaint is real or not. We're trying to speed that up, and I can do that best by using old people. The older lawyers that we have here that are working here part-time are doing an amazing amount of work. And getting these cases processed fast. Our target is to get a complaint processed within 90 days. So if you're interested, go to our website and take a look, and you'll find our advertisement for Adjunct Deputy Disciplinary Counsel. It's on our website. Look at employment opportunities, and you'll find, and we've got a complete job description in there. And we pay $75 an hour. It's not a heck of a lot of money. But remember, I told you when I closed my law firm, I went into a semi-retirement working at home and I kept 2 clients. Both of those clients I charged $75 an hour to. And just working part-time out of my home, I was pulling home $140,000 a year with no staff, no overhead. That's not bad. Supplemented my Social Security. So it's something to think about. That's my pitch. All right. And with that, here's the website, www.dbhawaii.org. Click on About and go down to Employment Opportunities and you'll find it. And that's all, folks. Thank you very much. Questions?
Okay, so yeah, let's get back to those 2 questions from the chat. So are there lawyers who practice includes advising and assisting other lawyers in connection with winding down their law practices?
I am not aware of anyone who's a professional consultant in winding down your law practice. However, we have a number of people here and people that I've worked with in the past that would be happy to talk to you. If you've got problems winding down your law practice, give us a shout.
Okay, and then here's one more question in the chat box. Is there a sample termination letter available for our information?
I don't have a sample. If somebody sends me an email and asks for one, I can send you a copy of what I used to send out in my law practice. It's kind of tailored for bankruptcy work, but you know, it's hey, another thing, samples. I'm glad you asked that. I have young lawyers asking me for samples too, so don't feel bad. There's this amazing thing on the internet. It's called Google. And you'd be amazed what you find there. I just go and Google something and ask for a form. I had a lawyer ask, how does he answer a complaint? And I told him to Google it, Google form answer. Just the thing is when you get something off of Google, make sure you exercise your own professional judgment before you charge a client for using it, because it may be wrong.
Yeah, there are a lot of jurisdictions or some jurisdictions that are, are alternative, in that jurisdiction, or their bar associations have samples, for this, that, and the other thing. But, there's a liability involved there and a few other things. So, not in this particular jurisdiction. I mean, it'd be kind of, the basics of, it doesn't have to be War and Peace. It just, thank you very much. It's been grand, blah, 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 and end of story. We're out of here. So, but I agree with, there are a lot more resources now than there used to be.
Oh, by the way, your insurance company also can provide you with that kind of information. When I was insured with ALPS, Attorneys Liability Protection Society, I think it stands for, they had tremendous resources and forms and stuff like that on client affairs.
Okay, looks like we have 2 more questions that popped up in the chat area. It looks like it relates to ODC. Does the lawyer have to live on Oahu to do part-time work for ODC?
No. One of our most prolific part-time adjunct deputy disciplinary counsel lives in Portland, Oregon, and another one that just recently moved from Palm Springs, California. So, no.
And looks like this is the last question in the chat box. What are duties of successor counsel?
What are the duties of what?
Of successor counsel.
Oh, what Carol was talking about is designated as successor. Successors actually comes in 2 flavors. You have successors that take over a law practice, and that is bound by Hawaii Rules of Professional Conduct Rule 1.17. And that's where you actually purchase a practice, even if it's just for $1. You take over the practice, it's yours, you own it. The other is an RSCH Rule 2.20 trustee. RSCH Rule 2.20 trustee is the person that you list when you register with the bar each year and you do your renewal. And that trustee will be appointed as an inventory attorney to go into the practice, find the client property, contact the clients, and try and get the property returned. You don't get to take cases as your own. You're just there as an inventory attorney and to return funds and files. You do so under court appointment, and you receive judicial immunity. So you don't have to worry about getting liable for any of the screw ups of the preceding dead lawyer. And that's always been a fear with a lot of people is, I don't want to step into your practice. I don't know what you've done. Well, if you go in as a Rule 2.20 trustee, you step in with absolute judicial immunity, as long as you stay to the practice of just simply finding stuff, giving notice to clients and getting the materials returned or securely destroyed under the rules. And ODC will work with you on that.
There's also the other term I think might have been in context of, the files and that sort of thing, successor counsel. And I meant that in the context of it's a situation where there has to be a withdrawal and somebody else has got to come in and take over the case. There's also that sense of successor counsel. Develop conflict of interest, whatever, got to withdraw, case is still going on, then, hand off to somebody that's going to, that one you do step into the shoes of. So there are different meanings of it depending on the context.
Everybody's got different situation, and we're always available to talk to you, particularly you're getting ready to retire and you want to go through what your particular situation is. Carol and I are available for you, and so are the rest of the staff attorneys here, although a lot of them are in their 30s, and when you talk about retirement, they'll pawn it off on us old farts, and we'll be happy to talk to you.
Hey, mine lasted 2 months before you called.
Okay, all right. Looks like there's no other questions, and with that, I thank you, Chief Tamm and Chief Richelieu.
Just call me Carol.
Okay. Chief Tamm and Carol. So thank you so much for presenting today on closing a law practice and succession planning. Next topic for October 5th is a Medicare Made Easy presented by Taryn Kumamoto. So be on the lookout for the registration link in the coming weeks. And with that, thank you all for attending today's coffee hour. We will see you next time. Take care.
Thank you, folks. Thank you.
Bye-bye.